Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happenings today. Nnamdi Kanu's robust legal team have been up and running, looking for ways and means to ensure that he comes out smoking, comes out free, come on the 8th of April 2022. As we speak, it looks like one of his legal luminaries have finally gotten the trick. Before going to the news proper, like you subscribe to our channel by clicking on the red subscribe button. Beside it, you see bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Let's go straight into the news of the day. Aloy Ejimakor, a lawyer to the detained leader of the indigenous people of Biafra, Ipob, Nnamdi Kanu, on Monday wrote an open letter to the Attorney General of the Federation, AGF, and Minister of Justice, Abba Malami. Reports has it that in the letter, Ejimakor said the update about Malami's requesting for further probe in relation to some aspect of Kyari's investigation has created a new legal connection between Abba, Kyari, and Nnamdi Kanu. The indigenous people of Biafra lawyer argued that if Malami can offer legal advice in the extradition process of Kyari, who is wanted in the United States for his part in fraudulent activities by Raymond Abba, popularly known as Hush Puppy, Nnamdi Kanu is equally entitled to any legal advice that imparts his prosecution. Let's read the letter in full. On the 13th March 2022, it was widely reported in the media that the Office of the Attorney General of the Federation issued a legal opinion and advice exonerating DCP Abba Kyari from the allegation of money laundering, which forms the main basis upon which the United States of America is seeking Kyari's extradition to America. One of such publications in a well-respected national daily was captioned, "Hush Puppy, new legal advice from AGF's office exonerates Abba Kyari of money laundering allegation." Inasmuch as this legal advice does not sit well with certain segments of Nigerians, and even the Americans that seek the extradition of Abba Kyari, it needs to be stated that the rendering of legal opinion or advice comports with the constitutional powers of the Attorney General of the Federation as preserved under the Constitution of the Federal Republic of Nigeria. Suffice it to say that this very legal advice exonerating Abba Kyari has created a new legal connection between Abba Kyari and Nnamdi Kanu. The connection lies simply in the fact if Abba Kyari is deemed entitled to such legal advice that will surely impart his extradition, Nnamdi Kanu is equally entitled to any legal advice that imparts his prosecution. In other words, the pertinent provisions of the Nigerian Constitution and Nigerian Extradition Act must be applied equally to all. Thus, Nnamdi Kanu is now entitled to a self-same legal advice which must include the following. 1. Under the universally recognized doctrine known as the doctrine of specialty, which pertains to extraditions, an extradited fugitive, whether rendition or otherwise, is subject to prosecution only for those offences for which he or she was surrendered, extradited, or renditioned. Nigeria recognized this doctrine under Section 15 of Nigeria's Extradition Act, which provides that fugitives surrendered to Nigeria is not triable for any previous crimes, wherein, in accordance with the law of any country within the Commonwealth, any person accused of an offence committed within the jurisdiction of Nigeria is surrendered to Nigeria by the country in question. Then, so long as he has not had any reasonable opportunity of returning to that country, that person shall not be detained, whether under this act or otherwise, tried or otherwise dealt with in Nigeria for or in respect of an offence committed by him before he surrendered to Nigeria, other than the offence for which he has surrendered to, or any lesser offence which may be proved by the fact on which his surrender was granted, or b. any other offence being one corresponding to an offence described in Section 20 of this Act, of the same nature as the offence for which he was surrendered, provided that the person falling within this section shall not be detained or tried for an offence by virtue of paragraph B of this section without the prior consent of the country surrendering him. Number 2. To be sure, the foregoing provisions were, as regards to Nnamdi Kanu, breached in all their material particulars. First, as of 19th of June 2021, when Nnamdi Kanu was abducted in Kenya, he was facing a 4-count charges, none of which included or bordered on terrorism. Today, the charges have been expanded to 15 counts that included and bordered on terrorism. Unarguably, this is a clear violation of the doctrine of sociality, especially in view of the provision that a person falling within this section, that Section 15 of Nigerian Extradition Act, shall not be detained or tried for any new offence without the prior consent of the country surrendering him. In this very instance of Nnamdi Kanu, the surrendering country is Kenya, and there is no evidence that her consent was observed or obtained before these new 15-count charges were brought. 3. Conversely, the same doctrine of speciality is also recognized in the Kenyan Extradition Act, which at Section 6, subsection 3 states that a fugitive shall not be surrendered or committed to or kept in custody for the purpose of surrender unless provision is made by the law of the requesting country or by an arrangement made with that country for securing that he will not, unless he has first been restored or had an opportunity of returning to Kenya, be dealt with in that country for or in respect of any offence committed before his surrender, other than A, the offence in respect of which his surrender is requested, or B, any lesser offence provided by the facts proved before the court of committal, or C, any other contradiction or extradition offence in respect of which the Attorney General may consent to his being so dealt with. Unarguably, these provisions have extraterritorial applications to Nigeria because, as Nigeria regarding Nnamdi Kanu, Nigeria is the requesting country, which fact that has been affirmed by the sheer compelled presence of Nnamdi Kanu in Nigeria. 4. Interestingly, Nigeria also strictly requires the self-same doctrine or specialty to be respected when it comes to fugitive extradited from Nigeria to other countries. Section 3, subsection 7 of Nigerian Extradition Act states that a fugitive criminal shall not be surrendered to any country unless the Attorney General of Nigeria is satisfied that he will not be detained or tried in that country for any offence committed before his surrender other than the extradition offence. In view of the foregoing, it has become necessary for the Honorable Attorney General to revisit the matter of these new 15-count charges presently standing against Nnamdi Kanu, with a view to urgently issuing a legal advice to the effect that all the new charges be withdrawn forthwith. Failure to do so will amount to a clear violation of the doctrine of speciality as enshrined in Nigeria's Extradition Act and equal protection of the law as preserved in the Nigerian Constitution. Hey, this is the day that Aloy Ejimakor is actually a learned colleague, not just a learned colleague. It looks like he has a way of always hand twisting the government when it matters the most. That's what